The death of Boston police officer John O'Keefe on a snow-covered lawn in the early morning hours of January 29, 2022, ignited a storm of suspicion, outrage, and relentless public scrutiny. His girlfriend Karen Reed now faces her second trial for his murder, accused of backing into him with her Lexus during a blizzard and leaving him to die. Prosecutors paint Reed as a jealous, intoxicated woman scorned. But her defense tells a darker tale, one of police corruption, a brutal beating inside 34 Fairview Road, and a cover-up to protect powerful men. As the retrial unfolds, the tiny courtroom is packed with friends and family from both sides, nestled up right next to the defendant and the lawyers in the case. Outside, tensions run high as state and local police keep order while supporters voice their opinions about the ongoing trial. The case has become a lightning rod, exposing deep mistrust in the judicial system. Truth feels elusive. In a trial where science and silence collide, the fight for justice has become a public crusade. I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. We're in the middle of yet another week of the Karen Reed retrial of the century. And we've been hearing a lot from expert witnesses. But what's interesting about expert witnesses in a trial, in a criminal trial, in any trial, is that they provide opinions, not facts. And that's important. Experts are providing opinions, not facts for the jury. The jury is the finder of fact. They're the ones who determine what the facts are and what they aren't. Not an expert witness. It's the jury. The job of the expert is to assist the jury in finding those facts, trying to explain things that ordinary folks may not understand based upon their own life experiences. And that's what we've seen in this case. And they explain some of the evidence in the case and what it means, and the jury will listen to that. They'll accept or reject it and help them in figuring out what happened. And it's subtle, but it's an important distinction, because the only people who determine the facts of the case are the jury. And sometimes experts disagree. Oh, in almost every case, experts disagree from each side, and sometimes they cancel each other out. But what's different in this case, much different in this case, is that these experts did experiments. And that's a big deal. They did experiments that are on video. These experts, they did the experiments on video, and the jury got to see them. So when the jury sees these experiments, which are replicating an SUV striking an arm, and they saw it from the prosecution, they saw it from the defense. Much different than an expert just getting up there and explaining to the jury what they believe and why they believe it. When you show them something, when you show them the alleged crime, first of all, it's very unusual. A lot of courts, a lot of judges might not allow it. This court, this judge did, and it's for both sides. So both sides presented their expert testimony through these experiments. And while the testimony is significant, I believe the visual experiments will have a bigger impact on this jury. And the question is, which experiments had that bigger impact? Which experiments do they believe more accurately depicts what is alleged here? Not necessarily what happened, what is alleged here. If you're the prosecution, it's what happened. If you're the defense, it's what they say happened but couldn't happen. Now, who will the jury trust? And a lot of times this comes down to the lawyers. Because in those closing arguments, which are coming up in this case, folks, the messenger who's going to deliver the conclusions of these experts and marshal the evidence, who during the course of these last 2 months has created a stronger bond with the men and women of this jury. That oftentimes can make a huge difference in a case like this, where everything is fought over and everything is very close. There's just A little bit of room this way, a little bit of room that way, that makes all the difference. Okay. Do I need to say it? Another big day inside the courtroom today. In Court TV crime and justice correspondent Matt Johnson joining us live from outside the courthouse in Dedham, Massachusetts today. Matt, great to see you. All right. This is the most important question on this day, which is, where are we in this case right now?
We are in the home stretch. We can't say it enough, right? And you're exactly right. Big moment after big moment after big moment. And that's just today, because the defense calling their final witness on day 31 of testimony in the Karen Read murder retrial, and it was their crash reconstructionist with ARCA. After that, the defense rested on the condition that the ARCA PowerPoint can be admitted as evidence and be back there with the jury when they deliberate. And then after that, another big moment. Hank Brennan made the announcement, a bombshell. He is not going to be putting on a rebuttal case, not calling any witnesses, not calling any dog bite expert or their crash reconstructionist. And then Karen Read also told the court officially she's not going to testify. And on the courthouse steps, once again speaking to the media, she said this. Take a listen.
Are you ready for closings?
He was terrific, as always, honest and stood by his analysis and just answered truthfully.
Are you ready for closings?
I'm ready. Yeah, I'm ready.
Why 90 minutes? What can we expect to hear?
All the facts, all the truth, everything that went wrong with their case.
What do you make of the prosecution not calling any rebuttal witnesses?
They don't have any analysis and they don't have any facts to present through Dr. Welcher, so they're done.
Karen,
what do you want the jury
you
to
said
know?
before you have butterflies at this stage. Are you
I do.
feeling those?
Yeah, of course.
Do you think your case is stronger this time?
I thought it was strong last year. It's stronger. Yes, we just called more witnesses and laid out more of the case.
How do you feel about the jury?
I feel good about the jury. Yeah, we selected them. I was there. I took part in it, and we chose fair and truthful, civic-minded citizens of Norfolk County. So I feel good.
What do you want the jurors to know as they go get their instructions?
I just hope they were listening. That's all I can ask for. They were in the same room I was for the last, I don't know how many days that was, 33 days.
31.
Given what we saw play out in the last trial regarding the verdict forms and what we now know that the jury found unanimously came to a conclusion, what are your concerns going into it this time around?
Obviously, after what happened in the first trial and what we heard from the jurors that came forward, we just have to have an even keener eye on the verdict form and the jury instructions.
Okay, guys, here we go.
Switch to the police investigation.
No more questions, guys.
And that last bit right there that she was talking about, remember, Vinnie, we've spoken to previous jurors that sat during the first trial, and they said that they were a bit confused and they were not polled at the end. So the charging conference tomorrow could be a little bit divisive, if not explosive, in the courthouse here behind me. We'll have to wait and see. They're starting at 10 o'clock tomorrow to go over those jury instructions. Obviously, the jury has the day off tomorrow. And then we also haven't lost any jurors. There is 18 people that have heard the case start to finish. So on Friday, we're going to find out who are the deliberating jurors of the 18. And then it's closing arguments and then go time.
Absolutely. 6 alternates made it through all this. That's amazing. Yeah, the charge conference important, the instructions important, and I just hope that this jury understands that if they're hung up on one count but they've reached a verdict on the other counts, you can fill out the form and you can deliver that partial verdict. Okay, let's get to the second ARCA expert, Andrew Rentschler. What were his opinions today?
Yeah, this was big testimony. This was the second day on the stand for him, mainly cross-examination, but he was also wrapping up some direct and then redirect. Dr. Andrew Rentschler, the crash reconstructionist with ARCA, did the testing on the SUV that was identical to Karen Read's, and he used that crash test dummy. He also lined up arm injuries at a 90-degree angle, and that was very visual for this jury. Here is what he told the jury, the 18 in the box, what his opinion is. Take a listen.
Did you reach a conclusion whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV.
Another big moment with this crash reconstructionist, like we saw with another defense witness, their pathologist, is the x-rays. He said that he looked at the x-rays of the victim, Officer John O'Keefe. You see him right there on your screen. There's no fractures, there's no breaks. So he said it's not consistent with a vehicle-pedestrian accident.
And it really seems this is the biggest point that the defense is going to make. You know, it comes back to there's no evidence of a collision. It's inconsistent with the collision. And they're going to lean on these experts, obviously. And then also perhaps asking the jury to use their common sense. If you get hit by an SUV, there would just be more. And what do these things look like on the arm? I could see that's where they're going. We know where the prosecution's going. So what did this expert say about the prosecution expert and his blue paint experiment?
Right. So remember, that was brand new testimony. It was Trooper Paul that had a completely different theory last year in the first trial. This year we had new crash reconstructionists with aperture, and they did that blue paint theory on the exemplar taillight, but they didn't show any impact on their test SUV. Well, with ARCA, they actually took this test that you're looking at and used a crash test dummy, used an SUV that was also identical, and put G-force behind it. And here is his findings and also his cross-examination on the same subject matter. Take a listen.
Did you determine, based on the testing by aperture, whether or not it was consistent, that paint test, that paint transfer test was consistent with Mr. O'Keefe's arm being damaged by the taillight at speed?
I did.
Okay, and what is that conclusion?
That does not represent that at all. The evidence from that test, again, it's only puts paint on the arm. So in no way does that determine or demonstrate how, if the arm struck the taillight cover, how the taillight cover could shatter, how the movement of the arm could interact with the cover to produce those abrasions.
Did you go, I'm sorry.
There's just no evidence of that. There's no steps taken to demonstrate how, if that's even possible.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his paint test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
That's just one of the examples how in the retrial of Karen Reed that this is really coming down to a battle of the experts. We just can't say it enough. And that's also a window, I think, in the closing arguments that we're going to hear from both Alan Jackson and Special Prosecutor Hank Brennan.
And that's all because we had all those people at the house coming and going, looking out the window, looking out the front door, driving past the house, and nobody witnessed anything. So the experts have to try to explain how it could have happened or did not happen. Anything else from cross-examination, Matt?
Yeah, so it was exactly what we expected Hank Brennan to get into today. Remember, before this trial even started, there was a pause in the pretrial hearings because of the grave concern by the court here after the new testing and the alleged misconduct and the improper communications by the defense and these experts. Well, today, Hank Brennan alluded to that, asked questions about it, and also asked the question, did you change your testimony as a result of those communications? Let's listen.
Did you testify under oath that they did inform me, yes, about testimony and situations and events that came forth in the event that I was not aware of?
I don't know. They told us about evidence. I don't know if it was specific to who testified to what, but they told us certain things, certainly, yes.
What I just said to you, are those your words, sir?
I have no idea. I mean, if that's what's in the record, I assume it is.
Would you agree it certainly helped you prepare?
It helped me prepare?
Yes.
It didn't make a difference to my analysis or conclusions.
Receiving that information from your employer, are you denying it helped you understand what was going on during the trial?
I'm going to allow that.
I don't even think that it did.
So I'm in the courtroom today, and I'm noticing with the jury, once again, like we've seen with many of the experts, they really love details and taking notes of expert testimony. In fact, Vinnie, some of the jury members have multiple notebooks that they walk in with each and every day, which is impressive in itself. I have seen them throughout the week and weeks flip back to prior testimony. They're comparing it. Obviously, they're not discussing it with each other. They can't do that until Friday. But they're comparing it in their mind to prior testimony. So this is a very smart jury, and they've paid close attention, including during those moments that we just shared today.
Yeah, absolutely. And kind of young, so they're a little closer to the age when they were probably in school. So they were still kind of, I don't know if I could take a note anymore. I don't even know if I could do it. It's been so long.
I don't know. I don't think that they're completely young. I think that there are, I counted, about 4 or 5 of the 18 to give you that look very young, maybe 20s, early 30s.
Yes.
But then there are some like older people too.
Wait, define older. Define older, Matt Johnson.
I don't know. I don't want to insult
anything
anybody.
Under 50 is young. Okay. Over 50, 50's middle age, and then you get 60, you're getting, you know, you're not old. All right, Matt Johnson, thank you so much. Wow, we're getting close to the end here. Unbelievable. Let's bring in our think tank. Join us live in studio. Criminal defense attorney, former state attorney in Miami-Dade, former assistant in DA in Atlanta, although you may know him as Norbert Clemens in the 1993 A Step Removed episode of In the Heat of the Night, that hit show. Daryl Cohen, ladies and gentlemen. Also with us, criminal defense attorney and law professor Meg Strickler, and criminal defense attorney, the man behind the glasses, Josh Schiffer. All right, Norbert. This is what I want to do. I want to play Hank Brennan today, and then I want your reaction to this moment. Take a look.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay. All right.
It was short and sweet. No rebuttal case from the defense. Is that a sign of strength or weakness from the prosecution?
Foolishness. The prosecution needs to have one rebuttal witness. So the jury leaves hearing the state's case, not having defense on them. And by the way, as Norbert, I was killed on set, and I'm back.
Yeah, he's re-arisen. But no, you want to have, I mean, if you're the prosecution, they want the last word, and that's such a rich thing to have. And it's a thing
they have the
to
last
use.
word in their closing argument.
They do, but I'm talking about now, the close of the evidence. They get both, and you want to utilize that. And I am surprised he didn't do anything with it.
Yeah, the moment that news dropped, my DMs just blew up with defense attorneys being like, are you kidding me?
Exactly.
If they're going to give you, through the process, the opportunity to get last word, I don't care what the witness says. You put up some little nubbin of testimony so that the last thing the jury hears in evidence is from you.
What I'm surprised is they didn't bring back their expert to take a look at the experiments that they did. Like, he's analyzing the blue paint experiment. Bring your guy back to take a look at the crash dummies.
Exactly, and you didn't need to go into anything deep. I'm talking 5 minutes of, do you see any problems with this? Tell me what your analysis of this analysis. Thank you so much.
And with their expert, there's the last word.
And do you still believe that what you testified to in direct was what happened? Thank you very much.
Exactly.
No further questions.
That's the end.
So we're getting, I mean, this is it. Like, all the evidence is in.
It was abrupt.
Shocking, shocking.
It's abrupt, but it's 31 days. I mean, it's a lengthy trial. That's a lot of evidence for this jury. For closing arguments now, they've got, to me, it's more important in a longer case because so much of the evidence was months ago. Like, I wonder if the jury, like, I know they've got notes, but do they remember about the cell phone temperature? Do they remember the testimony of John O'Keefe's mom? I mean, things like that. For the prosecution, they've got to remind this jury.
But collectively, when they go back, all the jurors collectively will put their notes together. And I do think they'll hopefully remember some of the stuff the prosecution put out there, and hopefully remember what the defense put in on cross and on their case.
I don't know if they're going to convict her of murder, but they'll certainly convict her of being a bad defendant, poor courtroom demeanor, horrible facial expressions.
So you think they'll vote guilty?
No, I
something?
don't. I would hope they would, because based on the evidence, as I see it, she's guilty of something. Not murder, but guilty of something.
What if it comes with the hung jury, though, again? That's something that
don't start with the hung jury. Don't start with the hung jury.
I'm telling you, wilder things have happened.
See?
When we come back, our think tank staying with us. We're going to take a look at more testimony from the final witness in the case, plus coming up next hour. Tonight on Vinnie Politan Investigates, the retrial of the century has caught public fascination, and the public has a clear opinion about the case. Tonight, we're asking, why does the public overwhelmingly believe Karen Read is not guilty?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
Karen Read is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
The Karen Read murder retrial. Live coverage weekday mornings, 8/7 Central, on Court TV.
Or did you reach a conclusion whether the biomechanical evidence in this matter is consistent or inconsistent with Mr. O'Keefe's right arm being impacted by the subject 2021 Lexus 570, resulting in a backward fall leading to the head injuries that he suffered?
I did, yes.
And what is that opinion?
My opinion is that the evidence is inconsistent with Mr. O'Keefe being struck on the right arm by the SUV and then moving laterally into the yard and falling backward onto.
And do you hold that opinion to a reasonable degree of scientific certainty?
I do, yes, sir.
The final witness providing the final pieces of evidence for the jury in the case of Karen Read. That's the second ARCA witness on direct examination providing his opinion. But the true test of any and every expert is, how do they hold up on cross? Let's take a look.
Could a person get their foot caught on a curb, sneaker come off, and then stagger backwards and fall on their head?
Objection, Your Honor. Yeah, let's go.
I'm going to allow that.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that, so it's just supposition, but I won't say it's impossible.
You think John O'Keefe did somersaults in the front yard of 34th Fairview? Is that what they're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
All right, who's winning that showdown?
Well, his facial expressions and his demeanor gave him a big X for me, regardless of any of the rest of his
You didn't
testimony.
like it?
I just tested it. If he was my witness, he would lose $10,000 or $15,000.
Isn't that funny? I liked him.
I loved him.
I thought he came off very credible. Isn't that hilarious? But that shows what the juror's seeing.
Right.
You know,
Right. So we
varying
got a hung
views.
jury here.
Yeah.
Let's not give him any ideas up in Massachusetts here. The way he is sticking to it, and this is the weird thing about these recreations and everything, right? Because the way this expert's being questioned by the prosecution is as if there was a collision. Where the whole point of his testimony is that there wasn't a collision. So it's kind of strange. A lot of times they're arguing over the results of the collision or how the collision happened. Here it's collision versus no collision.
And again, absolutely at the heart of this case, and we're going to discuss this now at the very end with the last witness that the jury's going to hear from is going to say, yeah, what collision? There's no collision. I'm an expert. There was nobody else that you're going to hear from saying, oh, that he was wrong. He was.
And the medical examiner was doing the same thing yesterday.
Oh, yeah.
Was doing the same exact thing.
Same theme.
Because so many times, right, especially in accident cases with accident reconstruction, there's an accident. Like, we know there was an accident. We've got two cars that are, you know, crashed and dented.
It's a huge industry generally on the financial
And we're just
side.
trying to figure out how exactly it happened. Here, it's so different, Daryl, because it's like, was there or wasn't there?
There definitely was. Wait a minute, there definitely wasn't. I'm confused. Depends on who I want to listen to and who I want to believe. But my question is, if you want to believe the prosecution, is there enough to show that it was beyond and to the exclusion of every reasonable doubt? I don't think so.
Yep, that's
And
a high burden.
really what we've focused in on is the Commonwealth did an absolutely great job, especially compared to the first trial, of establishing a prima facie case. They've got the experts, they've got the witnesses. But the entire defense made the Commonwealth go back and almost admit, well, that could have happened as well. Yeah, we can't shut down what you're putting out there.
So where does this leave prosecutors? Because I've been saying this throughout the trial. There's like 3 ways that they proved that there was an accident. The experts, right? If that doesn't work out, the alleged confession, I hit him, I hit him, I hit him. If that doesn't work out, then you've got the taillight pieces. So how does a jury go one by one by one? Do they look at all 3?
I think they're gonna go by all
is there any
3.
sort of, because there's 3 different ways, do they kind of pile on top of each other?
They have to go back. And in my view, the prosecution made a terrible mistake by not having at least one minuscule rebuttal witness, because you want to leave the jury thinking, you know what, that's really what happened.
An exclamation point.
Exactly.
You got it.
Yep.
In large font.
And then also
Okay.
the closing is going to be so good.
Oh, yeah.
Whoever does that the best and summarizes their point of view is what's really going to bring
you
it.
gotta give-
Closes off the other side's experts.
Yeah.
Yeah.
Now, let's take a listen to some more of the testimony here, because the big issue, there's a couple of issues, like where, if this happened, right, where was John O'Keefe when he got struck, and where was he after he got struck? Let's see how that went down on cross-examination.
When you were talking to the jury and giving opinions about where Mr. O'Keefe might have fell or not fell, you were discussing where Mr. O'Keefe was lying on the side of the yard, weren't you?
Where he came to rest?
Came to rest.
Well, approximately, we don't know the exact position, but yes.
You said 10 to 20 feet, didn't you?
I believe so, yes.
You said that 3 times, 10 to 20 feet. Do you think Mr. O'Keefe was 20 feet from the roadway?
Well, I think he's maybe 10 feet, but 20 feet is from, if you're hit by the car, you need some distance to travel. He couldn't travel just horizontally, or perpendicularly. So it would be at least 10 to 20 feet if you look at the total distance.
You have no idea where the point of impact was in this collision, do you?
Nobody does.
Did you ever see this photograph before, or part of this video?
I'm sure I have.
Well, when you say you're sure you have, are you guessing, or have you seen it or not seen it?
I'm sure I've seen this before, yes.
So you've seen this before?
Yes.
And when you looked at this video, did you look at the street and look at the area where Mr. O'Keefe was?
Sure, yes.
Sure?
Yes.
20 feet, Dr. Rensler?
The way I explained it to you, yes, sir, 10 to 20 feet.
Okay.
Love it.
I think I've seen it. I think I've seen it. Did you see it? I am not impressed with him in certain areas of his testimony.
I'm agreeing with Dan on this one. That particular snippet that you just showed does show a little bit of shaking of his confidence. But what he's saying is basically, he didn't move horizontally. He had to been hit, and then it somehow got moved over here. And he's saying what I thought was a good hit back, a confident thing to say is nobody knows.
It showed a really nervous state prosecutor trying to correct a narrative to match their theory against a witness who isn't having any of that today, who has no problem in just out front denying and refusing to let people put words in his mouth. So
I think he got words put in his mouth by what he testified to, John.
But he said nobody knows, and honestly, that's a win for the defense, because we have to have reasonable doubt here, and he says...
How important is the location of John O'Keefe's body? Like exactly where it was? And isn't that really on the investigators and the prosecution to be able to, you know, specifically say, okay, he was this far from the curb. His body was in this place. Like, we're looking at the street here. We see where the flagpole is. We always talk about the flagpole, but how close to the flagpole was he? The dash cam video is dark. It's not precise. Why wasn't there some sort of a measurement or a documentation
and normally
of this?
in an investigation, and I know we didn't get delivered proctor at all, and that's what was given to us in the opening from defense, which that may hurt them, because did we deliver proctor? No, we did not. But that would have been something to point out, is the lack of really good investigation, period.
And that's the core of the entirety of the defense's case, and a convenient hook for the jury to hang their hats is, this investigation was subpar, insufficient,
you know what that sounds
doesn't let you authorize.
Sounds like every defense case.
No, it
sounds like every defense case. It doesn't sound like a huge conspiracy. And I think they've altered. I think they're going to lean more into what you're saying, Josh. But to me, this is now transformed for the defense into a classic, they didn't prove it, reasonable doubt, which is the standard. I get it.
But if you took notes during the opening of the defense, they did not deliver what they said they were going to deliver.
I think what they'll say is, we thought that the prosecution would call the lead investigator, but they didn't.
I don't know.
When we come back, let's talk about the x-rays. Where have they been? Why did it take so long for them to show up inside the courtroom?
You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
He said that again and again and again. That's Justin Welcher, the expert for the prosecution, saying there were no x-rays. They didn't take x-rays. How do we know? I mean, the inference there is, well, his arm may have been broken. We don't know because no one x-rayed it. And then we take a look at the testimony of Andrew Rensher from today, the second ARCA expert, talking about the x-rays.
This is one of the exhibits, one of 3 exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the x-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record, medical records or these records?
It was. A series of the x-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Would it be appropriate to come to any opinions and conclusions in an injury analysis if you were to ignore x-rays, if they existed?
No. If x-rays exist, you need to review them. You need to determine what they represent and what injuries either did or didn't occur. You absolutely need to look at them. There's no indication on these x-rays of any fractures or any trauma or any type of injury to the bones or the joints.
Can we go to 229B's in Bravo with the court's permission?
Yes.
Do you see what's depicted in this photograph?
I can, yes, sir.
What is this?
So this is a x-ray. The forearm shows the ulna and the radius, which are the 2 bones in the forearm.
Do you see any defects, injury, trauma to these bones or anything associated with those bones?
I do not.
Okay, back with our live think tank in studio. Which is more powerful and persuasive here? The fact that the x-ray actually shows that there's no breaks or fractures in his arm, or the fact that the prosecution expert told the jury there was no x-ray of the arm?
And again, goes back to those notes. If those jurors wrote that down, like,
well, I'm sure Alan Jackson's going to remind them.
I am certain as well. And you know what? And he says in the direct just now, there's no indication of any issues.
Right.
And I think that's really telling. And then I loved his cockiness when he's like, well, of course we would look at the x-rays. And I think that makes you a good witness when you speak like that.
And of course, there was more testimony in this exchange about what x-rays show and don't show. And it seemed like they were very clearly moving away from this magical fact that the x-rays existed to, oh, those x-rays wouldn't show anything. And the cynic in me stands up and screams. Because you know when someone is waffling and pushing you away from one subject to another.
Right.
And that was exactly what was happening. Everybody picked that up.
Like they say on TV, but wait, there's more.
Yeah.
Dr. La Posada also talked about the x-rays. Okay, that's not Dr. La Posada. That's the blue paint experiment. But trust me, do you trust me that Dr. La Posada testified that she looked at the x-rays and they were clean?
Promises made.
Are you a lawyer? Are your lips
broken.
moving? You know, I laugh at that one. Not the doctors, but he knew the car was going to hit him. He was ready for it. So I don't know what validity that would have. And there was no snow and there was no cold.
Have you ever gone to a Thanksgiving dinner and had a discussion about something with your uncle who was an engineer or worked at that place that knew that was impossible? Everybody in that jury has that family member was like, no, are you kidding me? When you use that kind of demonstrative evidence, it injects the ability of a jury to really talk and to share stories, life experiences. That's where the magic of, oh, I get it, can really format and occur.
And I think there's probably going to be at least one person on that jury who may have had a fractured leg or arm, and you go to the doctor, you get an x-ray, and that's how they find him. Like, and there was none here.
You said no bruises, too.
Yeah, there are no bruises. Karen Reed also spoke about this after court. Take a listen.
After court.
Why would you see the x-rays for the first time? The Commonwealth didn't present them. They were in the autopsy folder, and RME saw them, and Rentschler saw them, and if memory serves, Welcher said he didn't see them.
Yeah, I'm wondering, how much does that undermine his credibility?
It does. Whether we like it or not, his credibility is undermined.
He didn't look at the file thoroughly.
Yeah,
by definition.
Hey, you guys can't even look through the file for the big x-rays. The doctors love looking at stuff like that. Man, that stuff's expensive.
This wasn't a minor, this is a major issue. It's the arm that has the injuries. It's the arm that allegedly is impacted. It is what got impacted, according to prosecutors, by the SUV.
It's a dead cop. It's bad enough they didn't shut down the entire universe to secure the scene, get the video from a... Now their own expert missed the x-rays.
So now we have, and I don't know if it's the same situation, but Hank Brennan was telling the jury that there were holes in the back of the sweatshirt. But wait. Now you have that piled on top of the expert telling the jury there's no x-rays.
No, but then you also had the proctor on the one thing at the autopsy room. Like the defense pulled some shenanigans as well. So
it's not about pulling shenanigans. It's about one side has the burden of proof.
But it's also shenanigans where that defense tries to avoid the burden of proof being what it is and try divide and multiply, and sometimes go to the other side so people won't look.
Hey, Daryl, would you rather be presented with incompetence or intentionally be misled?
The word is neither.
Oh, neither?
Neither.
So how much of that becomes a part of the closing argument for the defense?
Point it out. I think just point it out. I think a professional way is to simply point out the issues that occurred and point out that there was no holes except for the person that the criminalist had done. Just point it out. Don't do anything else. That's what I would do as a professional person.
When it comes to closing arguments, my favorite quote is, if you're explaining, you're losing.
Yes.
It's not the time to explain. You're not arguing. You're not advocating. Just like Meg said, you saw this, you saw this, you saw this. That judge is going to give you instructions. Please follow them.
Mention it and move on.
Yep, exactly.
Don't delve on it. Just mention it as if it's part of life.
Do you lead with it?
No.
I would bury it a little bit after I started.
It's in there, but it's a pylon at that point.
Exactly.
You've got a
It's not a pylon because I mean, the theme of the prosecution has been that the government is prosecuting someone who is innocent, that she is the victim.
No,
Is this, are these examples of further victimization? Does it work with their theme? Or do you just kind of say, do you even, I mean, it was a big moment. This was the sweatshirt that John O'Keefe was wearing. This is the arm of John O'Keefe. These are two big things. And if the defense doesn't correct it, it doesn't get corrected. So do you point out that, ladies and gentlemen, we had to show you the x-rays because they didn't show you the x-rays.
I do think he'll say that. I think that's how he's going to say it. He's going to say...
So say what we did.
Yeah.
We showed you what the holes were from.
Yeah, I don't know. I don't know if that one will come up. I just don't think he'll do that.
But again, I think you mentioned it, but you did.
We're out of time.
Exactly.
We're out of time. We're going to have to kill you again, Daryl Cohen, just like in the heat of the night. Daryl Cohen, Meg Strickler, Josh Schiffer, thank you so much. When we come back, I will reveal something else you need to know tonight. Plus, coming up next hour. Tonight on Vinnie Politan Investigates, the retrial of the century is wrapping up as the defense brings their case. And the defense has a theory about what happened to John O'Keefe. And tonight we are asking, where is the evidence of the defense theory?
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
It's the biggest story that we're covering. He is the boogeyman.
So many eyes have been on Donna Adelson from the beginning. A social media sensation, now a suspected killer.
Time to reveal something else you need to know tonight. Let's take a look at the big board. What's happening in the world of crime and justice? Verdict watch. Yes, another verdict watch for the so-called doomsday cult killer, Lori Daybell. So that means today we had some closing arguments in that case. Let's see what the pro se defendant, Lori Daybell, had to say to the jury.
I am no stranger to tragedy. The breaking up of a family is tragedy. On June 25th, 2019, Brandon Boudreau decided that I was responsible for his family tragedy. And I'm really sorry that he feels that way.
No, Your Honor, I'm going to object again to testimony.
All right, the jury is reminded that what is said in closing statements or closing arguments is not evidence, it is not testimony. The intent of the closing argument is for each side to argue what the evidence shows.
We've all experienced tragedies in our lives, and naturally people want someone to blame, someone to pay a price. My brother is no longer here. We can't ask him about that day. There were things presented in this case that I did not know.
And I'm going to object again to testifying, Your Honor, and ask to strike.
Sustained.
Things that I saw, I thought.
And again, I'm going to already ask to strike.
All right. The defendant cannot testify to things that were not testified to from the witness stand.
Because this is the theory the prosecutor wants you to see, it is limited. How can we say clearly when the law only allows for a skewed view of things? The devastation this family has gone through is the tragedy. After almost 6 years, it's time for healing.
Okay, Verdict Watch continues. We'll keep an eye on it for you right here on your front row seat to justice. I need you to take a look at the television screen. We have a missing child who needs your help. Justin Fitzpatrick. Justin is 17 years old. Justin may go by the name Nova. If you see Justin, pick up the phone, make a call, 911, 1-800-THE-LOST, or you can call the Attleboro Police Department in Massachusetts. Let's get Justin to a safe place tonight. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.